Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Each week, we dive into different employment-related topics that are on many Canadians' minds. I'd like to welcome my guest for today, Lior Simfuro, partner at Simfuro Tumerkin LLP. Before we get to your emails and phone calls, Lior, why don't you tell us why you feel it's so important that everyone knows about their employment law rights?
Well, Dana, I can assure you that pretty much everyone watching us right now has a job, is working, or is looking for work, and employment law impacts all of us. Every time you have a job, sometimes things are not going to be great. Sometimes there's going to be problems. Sometimes your job may be in jeopardy. Maybe you're going to be mistreated by your employer. Maybe your job is going to change. Well, I think everyone has the right to know what to do in those situations, to know how the law can help them. The law is really of no good unless you understand it, unless you can give it that opportunity to help you. And I like the fact that by being here and through this medium, we have that opportunity to help people, to reach people and educate people about their workplace rights. And a prime example of that is a situation that I dealt with over the past few days in the office. So someone watched our show last week, and I thought, okay, that was interesting. So they called me. So here's their situation. About 2 years ago, the heart of the pandemic, they were let go after about 4 years of working, and they were paid 4 weeks' pay and sent off on their way. This person thought that sounded okay. I got a week's pay per year of service. Well, he heard us on the show last week where I said that, no, you're owed more than that. So he called me. And sure enough, Dana, he is actually owed 6 months' pay, 6 months of severance. Now, the good thing is it was just shy of 2 years. There's a 2-year limitation period. We'll talk about that a bit more later. And if he had waited another month, he would have been out of time for doing something about it and pursuing his rights. I'm going to help him get what he's owed, but that's an important reminder there that you have rights. In this province, we have terrific employment laws, some of the best in the world. But if you don't know what those are, it can help you. So by watching this show, you'll be educated, informed, and you'll know what to do when facing a workplace problem.
So from the calls and emails you've been getting over the past week, what issue really stands out to you?
Well, certainly I keep seeing, and maybe it's because of the pandemic, maybe otherwise, severance offers being completely inadequate, a lot less than what they need to be. So even though in most cases I can count on a severance offer not being where it should be, what I'm seeing right now is severance offers being even 30% worse than usual. You may see someone that's owed 6 months severance offered 1 month, or someone owed 20 months being offered 4 months. So that delta, that gap between what you're owed and what you've been offered, I've seen it increase. So it's even that much more important than ever, if you lost your job, if you're worried about losing your job, to get that legal advice and get it right away.
Wow, 30%, that's huge. That's, like you're saying, it's a huge delta. So if you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, EmploymentLawyer.ca. Let's kick things off by taking our first call. Lior, these calls come in from your radio shows across Ontario and Canada, where you take questions live from listeners about their employment law issues. Take a listen.
Friend of mine has worked for this company for about 27 or 28 years. Their company is going to close down, and what they've done is they've told them in November that they're going to close down next November. So they give them basically a year in advance notice that they're going to shut down. Do they still have to pay severance at the end of that, and what kind of severance would this guy be looking for?
So another severance question.
Another severance question, I see a lot of those. And this is not an uncommon situation. An employee getting advance notice of their termination. We call that working notice. So we talk about severance often on the show. One of the ways that an employer can meet its severance obligations is actually by not paying severance, by providing sufficient advance notice of termination. So this person received 12 months advance notice that they're going to be out of a job. So the real question is that enough? Because if it's enough, they're not owed anything else. If it's not enough, the employer has to make up the difference by paying them severance at the end of employment. So I can, of course, tell you how much severance they're owed, but I want to show you, and I want to show all our viewers how they can find out for themselves how much severance is owed. We created a tool. It's at PocketEmploymentLawyer.ca, and when you go there, you'll see our severance calculator. So let's go to the severance calculator at PocketEmploymentLawyer.ca, and let's see what this person is actually owed. So 58 years of age, 27 years of service, received some 12 weeks of notice. Well, we see that, in fact, they're owed as much as 24 months. Now, the amount of notice that they received comes off the top, but there's still a significant delta there, a significant amount that they're owed. So chances are, even if you've received advance notice of your termination, that amount of notice is not sufficient to make up for the severance that you're owed. Still important to check out for yourself at PocketEmploymentLawyer.ca. By the way, they're free and anonymous. Everyone should use it.
Absolutely. Okay, let's take a short break. And when we come back, employment lawyer Lior Samfiru from EmploymentLawyer.ca will answer more of your questions. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from EmploymentLawyer.ca is answering questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Before we get to our next call, Lior, let's move on to our main topic of the show and discuss how to deal with workplace harassment. What kind of conduct is considered workplace harassment?
So Dana, first I want to say that one of the most fundamental rights that all employees have is the right to work in a healthy, supportive work environment. But unfortunately, sometimes that work environment becomes toxic or poisoned. It is a common thing. So we want to talk a bit about what that is and how to deal with that. Now, workplace harassment is a very broad term, and it generally means any type of workplace conduct that objectively could be considered to be unwelcome. So that's a very broad topic, but it needs to be, because what may be considered harassment for you may be different for me, and the law understands that. So if you're subject to the type of treatment that makes you uncomfortable, the type of treatment that if an outside observer were to look at it and say, yeah, that's not right, that's not appropriate in the workplace, that falls under the broad heading of workplace harassment, and frankly, that has no place in the workplace.
So does an employer have a duty to prevent workplace harassment, even if it happens outside of the office?
So an employer has a very strict duty to investigate and eradicate workplace harassment. Gone are the days when an employer can say, oh gosh, boys will be boys. That can't be the case anymore. An employer has to take it seriously. And if there's workplace harassment, they have to deal with it and deal with it properly. Now, you mentioned conduct outside of the workplace. It doesn't just end in the four corners of the job site. If there's a type of conduct that could impact the workplace, but the conduct itself happens outside of the workplace, the employer may still have to be involved and do something about it. If employees pick on or treat each other improperly outside of the workplace, and the chances are that that's going to impact the job site, it's going to come in and flow into the workplace, then that is still an issue that an employer, once they become aware of, has to deal with it. You can't ignore it as an employer. There's going to be significant consequences if an employer doesn't deal with workplace harassment. It could be a violation of at least 3 statutes. So it's one of the things that employers now have to be aware. It hasn't always been the case. When I started practicing, it wasn't really a thing. But it's a big issue right now, and as an employee, you have to know that you have rights.
Okay, so what should an employee do if they are the target of harassment?
So first thing you want to do is you want to make sure that your employer knows about it. You want to give your employer that opportunity to deal with it. You don't want the employer to say, well, I didn't know, you didn't tell me. You should tell your employer. Now, depending on your workplace, there may be different people you can talk to. Maybe it's HR. Maybe it's the owner of the company. Maybe it's your direct boss. And in fact, if you ask, you probably already have someone in the workplace that's designated as the person that you should go to if you're dealing with workplace harassment. So first of all, I want you to always document. We talked last week about putting everything in writing. If you're being mistreated, find a way to document that so there's proof. The harasser is not going to put up their hand and say, yes, I did it. So you're going to have to find a way to document that, whether it's recording, putting things in writing, sending someone an email confirming. Then go to your employer with that information, put the onus on them at that point to investigate and to take measures to eradicate that harassment.
So we just talked about the employer and how an employer should respond, but what are the steps an employer has to do? Because obviously there's legalities involved.
So first thing you do is you take it seriously, but it starts with that. But then you have to investigate. And sometimes that may mean the employer itself investigates and asks questions. In other situations, that may mean bringing an outside investigator that's an expert in these areas to conduct that investigation, to make sure that you understand what happened. And on that basis, you decide on the steps that you have to do to deal with it. Maybe all you have to do is provide additional training about what's appropriate in the workplace. Maybe you have to actually discipline someone that wasn't meeting your policies. Maybe you have to let someone go. So it all starts with that investigation, which is a mandatory and necessary step.
Okay, so what can someone do if their employer fails to stop the harassment or they get punished for speaking out?
And I know that's a concern people have. Well, what happens if they don't do anything about it? And you're right, that is an issue. The law says you have to, but some employers may not do it. Well, if you can't deal with it internally, i.e. talk to someone and have them deal with it, then you have to deal with it externally. Then we have to get involved and we have to give the employer the push that they need to deal with it. In some cases, the fact that you're subject to workplace harassment and your employer is not doing anything about it can be considered a constructive dismissal. So we may be able to get an employee that's harassed out of the workplace with compensation. So if dealing with it internally doesn't work, you deal with it externally. And remember, you cannot legally be punished for raising harassment issues. Even if they're not ultimately corroborated, you cannot be punished. That's called a reprisal. That's completely illegal.
Okay, let's get to more of your questions. Here's another caller from your radio show. Take a listen.
Leo, I'm 60 years old. I've been working as a senior sales rep. I make a pretty good income. Company has hired a couple of new sales reps, basically half of what I make. They would love for me to just retire and walk off into the sunset, and I'd really love to go, but I don't want to go. I want them to pay me to go. What do I do?
Do you see a lot of cases with older employees being pushed out?
I do, and we have an aging workforce these days, so I have seen, unfortunately, a lot of employees that feel that because of their age is being held against them, they're being pushed out, sometimes being flat out let go. So let's start with the idea that we don't have mandatory retirement in this province. It went away some 15 or 17 years ago. So it's gone. It doesn't exist anymore. And you have a right as an employee to work as long as you want to work, whether it's 65, 75, or any other age. And an employer that lets you go because of your age, even if it's part of that decision, that's illegal. That's a human rights violation.
Wow.
So if you feel you're being pushed out, well, talk to someone about it. We talked about that before. Tell your employer that that's not acceptable. And if, in fact, you are let go, you got to give me a call at that point.
Right.
But the reality is that an employer that makes decisions based on an employee's age, it's illegal, and the law does not look kindly on that at all.
Okay, let's take a short break. And when we come back, Leora from EmploymentLawyer.ca will discuss your rights when your employer asks you to relocate and a company's duty to accommodate their employees. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome Welcome back to Ask a Lawyer. Lior Samfiru from EmploymentLawyer.ca is taking questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We still have lots more to discuss. Here's another question that recently came in. Take a listen.
My company is looking to relocate us to one of two locations, one being about 70 kilometers away and the other being about 45 kilometers away. And basically they're telling us there's not too much we can do, that we have no choice. Right now I'm 2 kilometers from work. Like, I've been with the company for 20 years now, purposely moved closer 15 years ago just to be closer, and now they want to relocate us.
So they don't have a choice?
Well, there is a choice.
Okay.
Obviously, if you're living close to work and now all of a sudden the workplace is relocating and you're going to be far away, that's a significant change. And anytime we use the word significant change, there's another term we have to think about, and that is constructive dismissal. If the employer makes a significant change to the terms of employment, you may be able to consider that a termination. Same thing with a relocation. So here's a rule of thumb that I use. If the relocation means that now you're going to take more than an hour to get to or from work, if that hour is impacted, then that's a constructive dismissal. So it's not about the kilometers, whether 20, 40, 70 kilometers, it's how it impacts you in terms of time. So if now it's going to be an extra hour, you may be able to say no. By changing the workplace, that's a constructive dismissal. Now you have to pay me my severance. If that's your situation, you know what to do. You give a call.
Okay. We have an email question from Manuel. My doctor says I need to work shorter shifts because of my illness. My employer refuses to accommodate and won't do anything until I share more information about my condition and get a second opinion. Is that fair?
It's not fair, but more importantly, it's not legal.
Really?
Your doctor is judge and jury with respect to your ability to work and the accommodation that you need. And once your doctor says you need accommodation, your employer has to provide that accommodation unless it's unbelievably difficult to do so. So that duty to accommodate, one of the most basic principles of human rights laws that we have. Now, the other thing I want you always to remember is that you do not have to tell your employer what is the nature of your medical condition. Whether you're suffering from depression or you have a broken bone doesn't really matter. What matters is your ability to work. You have a right to privacy when it comes to the nature of your medical condition. Your employer also can't demand that you get a second opinion. Your doctor is the ultimate decision maker here, and if your employer doesn't accommodate you, if your employer doesn't agree with your doctor, doesn't listen to your doctor, believe me, that's illegal.
And what do you do at that point?
Well, at that point, you have to give them a bit of a push, kind of a kick in the pants sometimes, which is where I come in to make sure that an employer complies with their legal obligations.
Okay, let's take one last break. When we return, Lior from EmploymentLawyer.ca will discuss the threshold for terminations in Ontario. Stick around. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Lior Samfiru from EmploymentLawyer.ca is answering your employment law questions. You can connect with his team by calling 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We have time for a few more emails. Here's one from Sean. My boss told a coworker that because the company only has a dozen employees, they don't legally have to give a severance when we're fired. Is that true?
Well, Dana, that's one of the most common misconceptions you hear when it comes to severance, that the company has to have a certain size of a payroll, a certain size of a company before they have to pay severance. False, completely wrong. The size of the company's payroll, number of employees, does not impact your severance. Whether you work for a company with 1 employee or 1,000 employees, you're still owed severance. In fact, you're going to be owed the same amount of severance. Your severance is based on your age, your position, and the length of your employment, not the size of the company's payroll. So how do you find out if you want to know how much severance you're owed? You can do that right now. You grab your smartphone, your desktop, your tablet, whatever you want, and you go to PocketEmploymentLawyer.ca. Again, it's PocketEmploymentLawyer.ca. You'll see our severance calculator tool there. You can answer a few questions and you find out in seconds how much severance you are owed. By the way, free and anonymous, whether you lost your job, whether you're worried about losing your job, maybe you're just curious. You'll be surprised by what you see there, but it's completely accurate, Dana.
Okay, Sasha sent this email in to ask@employmentlawyer.ca. I posted comments on my Facebook page that were slightly critical of my employer, specifically concerning health and safety protocols. I was fired a few days later for bashing the company online. Because I was fired for cause, I can't get EI or severance.
Well, certainly you have to remember that, or you have to at least assume that if you post something online, any social media, it's not private. Even if you have your privacy settings on there, you have to assume that your employer is going to be able to see it. So if you're posting something you don't want your employer to see, well, don't post it, because your employer will see it and they will respond to it. Now, I don't know that it's a good idea to bash your employer online. In fact, I don't think it is a good idea. But the real question is not that. The real question is whether or not this person criticizing her employer online, whether that amounts to just cause for dismissal, whether what she did was so bad that she's deprived of EI and severance. We have to remember that the only way you can be deprived of severance and EI is if you've done something so bad that it makes it impossible to continue employing you. That does not rise to that level. So because of that, even though maybe she did something she shouldn't have, and I'm not going to argue with that point, it's not enough to deprive her of her severance. So if she's not going to get it, that's a wrongful dismissal. She needs to give me a call. But there's an important point here to be made about social media. A lot of people don't understand that. They think it is private. It's not. And time again, I've seen employees being disciplined for what they post online. Definitely something you want to keep in mind and be mindful of.
Absolutely. Somebody will see it. If not specifically your manager, someone in the team.
They'll tell them
That's right.
And they'll find out about it. But ultimately, that does not mean you can be let go without compensation.
Great information, Lior. Thank you so much for being here today. You can catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show at EmploymentLawyer.ca, visit cp24.com/askalawyer. Join us again next week as we zero in on what you need to know about wrongful dismissals. Thanks for watching.